The Supreme Court is facing a crisis. A staggering backlog of emergency cases, primarily stemming from the Trump administration, has brought the highest court in the land to a standstill. These are not your typical cases. They are urgent pleas, demanding immediate attention and impacting millions of lives. From the fate of birthright citizenship to the legality of firing agency heads, the stakes couldn't be higher. 9 emergency applications hang in the balance, each one a ticking time bomb with the potential to reshape American society. The court's inaction is unprecedented. Weeks have turned into months, with some cases fully briefed and ready for judgment, yet the justices remain silent. The silence is deafening, leaving the nation in a state of anxious anticipation. This is not how the Supreme Court typically operates. It is designed to be a swift arbiter of justice, particularly in matters of national importance. The current state of paralysis raises serious questions about the court's ability to function effectively in this new era. The court's recent decision on the transgender military ban only adds to the confusion. The ban, a controversial Trump administration policy, was allowed to proceed while the case makes its way through lower courts. The justices offered no explanation for their decision, not even a dissenting opinion. This lack of transparency is deeply troubling. It suggests a court in disarray, divided on ideological lines and unsure of how to proceed. This lack of clarity undermines the public's trust in the institution. The Supreme Court derives its legitimacy from its ability to provide clear, reasoned judgments, regardless of political pressure. The recent silence and the unexplained ruling on the transgender ban erode that legitimacy. The American people deserve better. They deserve a court that is transparent, decisive, and committed to upholding the Constitution. The justices have several options at their disposal when it comes to emergency applications. They can deny the application outright, essentially siding with the lower court's ruling. They can grant the application, providing the Trump administration with the relief it seeks. They can schedule oral arguments, allowing for a more in-depth examination of the legal issues at play. They can move the case to the merits docket, expediting the process and ensuring a faster resolution. Or they can issue an administrative stay, maintaining the status quo while they deliberate. Each pathway has its own implications, and the justices must carefully weigh their options. Their decisions will have far-reaching consequences, shaping the legal landscape for years to come. The pressure is immense, and the world is watching as the court grapples with these momentous decisions. The very future of American jurisprudence hangs in the balance. Section 4. The weight of emergency impact and implications. This backlog of emergency applications is taking a toll. It's not just the fate of these specific cases that's at stake, it's the court's ability to function effectively. The sheer volume of emergency requests from the Trump administration is overwhelming the system, consuming time and resources that could be devoted to other pressing matters. Regular court business is being disrupted, and the justices are falling behind on their already demanding schedules. This backlog has implications beyond the walls of the Supreme Court. It's creating uncertainty and instability throughout the legal system. Lower courts are left wondering how to proceed, knowing their rulings could be overturned at any moment. Businesses are hesitant to make long-term plans, fearing sudden changes in the legal landscape, and ordinary Americans are left in limbo, their lives on hold as they await the court's decision. Section 5. A nation on hold deciphering the stalemate. So what's behind this unprecedented backlog? Opinions vary widely. Critics of the Trump administration see it as a sign of presidential lawlessness, a deliberate attempt to circumvent the normal legal process. They argue that the administration is flooding the courts with frivolous requests, hoping to overwhelm the system and achieve through brute force what it cannot achieve through legal arguments. Supporters of the administration offer a different explanation. They blame nationwide injunctions issued by federal judges, arguing that these injunctions are preventing the administration from carrying out its lawful duties. They see the administration's frequent emergency applications as a necessary response to judicial overreach, a legitimate attempt to restore order and enforce the law. The truth likely lies somewhere in between these two extremes. Whatever the explanation, one thing is clear: this backlog is a symptom of a deeper dysfunction within the American political system. It's a sign of a nation deeply divided, where even the highest court in the land is struggling to maintain its legitimacy and authority.